concludes our 9 a.m. docket.
Thank you, Mr. Shima. I'll now call 126716, State of Kansas versus Yusuf McCray. Mr. Hodgkinson.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Yusuf McCray. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you, Your Honor. Your Honor, I was going to open my comments today just as I was getting ready for this case and reviewing the landscape of Second Amendment jurisprudence over the last few years and sort of recognizing Bruin coming down when it did, and then a lot of people saying what they thought that meant. And then a couple of years later, as Rahimi has come down, since we filed briefs in this case, with 5 concurring opinions and a dissenting opinion by Justice Thomas, who wrote Bruin, who said, you didn't get Bruin right at all. And looking at commentators who, some people think Rahimi completely overturned Bruin, and others who think that, Rahimi is just a narrow application of Bruin. And so that's the legal landscape that we are all walking into. So I guess I say good luck to us all as we try to figure this out. What I do think I know from these cases is that if a state law, for example, impairs the right to bear arms, if at least the person that it's impairing is within the class of people protected, then the state bears the burden of proving that regulation, now we understand from Rahimi, falls within the regulation, the historic sort of regulation of things that allows somebody to be dispossessed of firearms or weapons. I don't think there's any dispute, maybe my counsel will disagree with me, I don't think there's any dispute that Mr. Yusuf, that Mr. McCray in this case falls within the protected class, and that he therefore has the right to bear arms. And so the burden then falls on the state under these cases and under Rahimi still, for the state to show that the governmental regulation in this case is justified. The state in this case has taken a couple of directions on this. Sort of in their brief, they cited some lower court cases that came out before Rahimi that were talking about different kinds of basis, historic basis, possibly for such regulations. And they cited some cases, for example, how historically governments back in England or in other places in the early United States prohibited Catholics from having guns, or prohibited Black people from having guns, or prohibited Native Americans from having guns. And if, after all, we can have those kinds of prohibitions, then what's wrong with this regulation, says some of the courts cited by the state. And I think that, Rahimi does not support that. They say that why we do not suggest that the Second Amendment prohibits the enactment of laws banning the possession of guns by categories of persons thought by the legislature to present a special danger of misuse. I think that takes that away. It does apply, and this is the state's more strong argument under Rahimi, it does apply once a court has found that the defendant represents a credible threat to the physical safety of another. And in fact, that was really the holding of Rahimi, dealing with a person who was subject to a protection from abuse type order, where a judge had found that Mr. Rahimi, and substantial evidence to support it, had found that Mr. Rahimi was a credible threat to others, and therefore was subject to this. So the question in this case, because Mr. McCray was convicted under a Kansas statute that says a person who has been convicted of domestic violence battery is prohibited, is dispossessed from their right to bear arms for 5 years. And so the question, I think, for this court is, does a conviction, a misdemeanor conviction for a domestic violence offense effectively represent an independent finding by a court that Mr. McCray in this case represents a credible threat of physical safety to another? And our argument, unsurprisingly, is it doesn't. That when you look at, and I thought it was interesting as I was reading Rahimi getting ready for this, how many times Chief Justice Roberts makes that statement about that, there's this finding in this case, a finding, an individual finding that Mr. Rahimi in that case was represents a credible threat to the physical safety of another. And noted and it allowed Mr. Rahimi, for example, to argue that he wasn't, that he had a due process idea of being able to go to court. And when somebody comes in and says, I think he should have a protection from abuse order because he's a credible threat, it gives him the ability to say, no, I'm not. And to have a finding on that. A conviction in Kansas for a domestic violence battery does not include necessarily a finding that that person is a credible threat to others in the future.
Well, there is a comparable federal statute, 18 USC 922 G9, right?
Yes.
Except that statute, the federal statute doesn't even have a temporal limit of a 5-year like Kansas does. And multiple federal appellate circuits have reviewed the same challenge and have found that in the context of a conviction, where we're not dealing with a temporary restraining order, that is the equivalent of a finding, given that the statute itself recognizes this class poses a risk of danger.
Yes, Your Honor.
How do you deal with all of the federal, I mean, it's the 6th Circuit, 10th Circuit,
Fourth Circuit.
4th Circuit,
Yeah.
8th Circuit.
They're all wrong, Your Honor.
Okay.
I mean, they all suffer from the same problem, that they're making this equivocation, they're making this legal equivocation of a conviction for this equals a finding in every single domestic violence battery case that person continues to, I have to keep reading it every time, represents a credible threat to the physical safety of others in the future. And
The inference is too much of a stretch then.
that's not an element of a domestic violence battery conviction. It's not a thing that was at issue in a domestic battery violence case. And by the way, a person doesn't even have the opportunity to argue that that's not true in a domestic violence battery case, as a person does in a protection from abuse.
What about a murder?
I think your question is
What you're saying is all federal case law equating a domestic violence battery to a credible threat of safety to the others in the future is wrong. And I'm saying let's substitute murder in the first degree. All federal case law equating murder in the first degree as a credible threat of safety to others in the future.
Yeah, Your Honor, it would be the same. It is the same because that's the past. Rahimi is focused on findings, individual findings about the future. And a finding that a person even has committed a serious crime as first-degree murder in the past does not equivocate to a finding that person is a credible threat in the future. That those two things are different. Obviously, there's going to be overlap on those things. And so we can imagine a world where a judge could find in a particular case, either for domestic violence battery or first-degree murder, that a person is going to be, is a credible threat to the future. But that's not done in a murder case. It's not an element of murder.
Right, but I'm just saying, would you agree or disagree that you can dispossess a felon who has been found by a jury to have committed first-degree murder, premeditated murder, that's wrong too?
So that's not the case before us.
Correct.
Because it's a misdemeanor. And so there's certainly a stronger language, and my colleague has cited this language. There's language in some of these other cases that talk about the historic tradition of being able to dispossess felons for any kind of crime, I guess. And that's being litigated out in the world, whether these sort of categorical bans against felons in general or specific kinds of felons, I suppose, whether that would be fall under any sort of this historical regulation allowing dispossession of firearms. I learned as I get ready for this, that's ongoing litigation, even for felons. This language by Chief Justice Roberts and Rahimi, this idea that we do not suggest the Second Amendment prohibits the enactment of laws banning the possession of guns by categories of persons thought to be by a legislature to present a special danger of misuse. This idea that that this historical tradition does not allow sort of these large scale categorical dispossessions. And so I'm not willing to concede that, Your Honor. We concede it's a different issue because we're not dealing with a felony here. And that is one of the distinctions and distinctions recognized in some of the other cases that certainly that you've talked about, Your Honor, and found in, I recognize, and found in those federal cases to not, to make a difference. But certainly the underlying claim here is that in none of those cases, and especially in these cases, is that that person sort of found individually after an opportunity to respond to be a credible threat to the safety of others.
Your answer started with the class and then it focused on the individual. And so I kind of like to move back to the class and that class categorical distinction that the Supreme Court has seemed to recognize. I think we all agree that if we look back to the history, our country's history about treating domestic violence has changed. So we recognize that we're probably not going to find that perfect fit and we're looking at the analog. But as we look at that analog, don't we have a rich history of legislative and scholarship in this area of the law on domestic violence and just even generational and familial tendencies and other tendencies that have been discussed that might lead people to proclivities to repeated offenses? How do we consider that and how do we do that within our framework of analytical structure that's our historic framework?
So if I'm understanding your question, I mean, the rationale, certainly of some of these federal courts, Justice Wall, that are out there is sort of this idea that, look, legislatures have determined and the Congress has determined that people who commit domestic battery are dangerous, sort of just as a class. And based on some of this, maybe the social science research you're talking about. Am I following your question right, Chief Justice?
Yes.
Yeah. And so, again, it goes back to, all right, that would be, I think I see that as supportive of a particular finding in a particular case that a person is a credible threat, that it could support that kind of a finding, but it doesn't substitute for an individualized finding with due process, thereby dispossessing the person of their right to bear
And that's
arms.
where I'm not following, because getting back to Justice Standridge's question about treating all first-class murderers the same, you're suggesting that can't happen either? That there has to be in a first-class murder a specific finding as to that defendant?
I'm suggesting that, can I answer your question,
Yes,
Justice?
yes,
Justice?
please do.
I am suggesting that Rahimi doesn't support that proposition. Now, there's different law about, and unresolved law about whether we can have this class of felons that can be dispossessed in general, because there is discussion in these other cases about that historic tradition that's not being litigated. So that's the distinction I would make. I don't know. That might be another. That's not the claim in this case. It can't be because this is a misdemeanor, not a felony.
So you would class it in the class of misdemeanors or the class of domestic violence, or what's the break? Where's the break?
The break is what Chief Justice Roberts over and over says is there a finding based on, whatever the predicate is that the government is using to dispossess the person of their right to bear arms, does it include, and I know it doesn't have to be a perfect fit, that's certainly what Rahimi says, but does it include a finding, an individual finding that that person represents a credible threat of physical safety of another? If so, then it can fall under these surety laws or these going armed laws that the United States Supreme Court did say met the government's burden of proof to allow the dispossession of a person with the protection from abuse order. But that's not true in this case. There is no such finding in this case.
And are you relying, it sounds like you're relying in your argument on the language that suggests it has to be a finding by a judge, as opposed to whenever there's a class, lines drawn by the legislature. I mean, it can be argued the legislature is making that finding.
That there has to
class of people is an ongoing threat.
Yeah, that's correct, Your Honor. I mean, again, I think that
Does Rahimi prohibit? I mean, does the language of Rahimi prohibit that? Is that what you're arguing?
Chief Justice Roberts says, we do not suggest the Second Amendment, section prohibits the enactment of laws banning the possession of guns by categories of persons thought by a legislature to present a special danger of misuse. They're not saying that you can do that. So,
Can you, I'm sorry, can you just focus on that sentence again?
yeah,
Just for my clarification, it says we do not suggest the Second Amendment.
prohibits the enactment of laws banning the possession of guns by categories of persons thought by the legislature to present a special.
Right, so that's a double negative that cuts against your argument. Is
Yeah.
we do not suggest the Second Amendment prohibits
But they go
exactly
on.
what we're talking about.
Yeah, they go on to find and hold, I didn't have it here. I mean, the government and Rahimi was also suggesting, look, you said in previous cases that you can have people who aren't responsible and that you can have this special class of people who you think are not safe to have guns. And Chief Justice Roberts specifically rejected that claim in the majority opinion. And so it is our claim that the government is not permitted to do that.
So you're getting a little confused from my reading. I'm not saying you did it, but my reading of your petition for review and what you're saying now. Are you saying that there has to be an individual finding by a court that a specific individual is a danger, poses a future danger to some other individual? Without that, you cannot ban these firearms.
That if the government is justifying their regulation under the things that were used in Rahimi, the surety laws or the going armed laws, that yes, that there has to be an individualized finding with due process protections that that person is a credible threat to others.
And that's true. Your argument is true regardless of whether that's a felony or a misdemeanor.
It would be true. What I'm acknowledging is there might be another basis, right? The whole idea under Rahimi is that the government has to come in and say, here's the theories, the historical tradition of regulation that we're relying on to say that we can do that in this case or this class of cases. And the only justification I think that Rahimi certainly relied on was these surety laws and going armed laws. And if that's what the state's relying on here, I think they are, then yes, then you have to show what Chief Justice Roberts said was the essential component of those things historically.
Regardless of the severity of the crime.
Yeah, I think that will be a separate argument.
This has got to be a finding in any kind of a case, regardless of whether it's a felony or misdemeanor, in order to have this prohibition.
So I think that will be an argument in felony cases. That's going to be an argument. And in those cases, the state, I think, will come in and say, look, but we have all these citations to cases that have said there is a historical tradition of being able to dispossess felons in general. And then the Supreme Court's going to have to decide whether they meant that or not, or whether that's true in those cases or not. So that's an issue for another day, I think, because the state can't argue that that tradition of being able to dispossess felons applies in this case.
But we can.
And that is my fault in my petition, Your Honor.
But the way you stated the issue at the beginning of your argument is we can limit our focus to domestic violence, misdemeanor convictions under to that category.
Yeah, that's what this case, that's all that's in front of you.
Okay. And one final thing, you're not making any state constitutional claim here.
No.
Can I return to the sentence you read from Rahimi? The sentence that follows it says, that matches the surety and going armed laws, which involve judicial determinations of whether a particular defendant likely would threaten or had threatened another with a weapon. I think that sentence is as confusing as the sentence you've been reading, personally, because the matches the surety and going armed laws, to me, references kind of that broad classification again. And then the last sentence seems to be more specific to the, but anyway, what is your reading and how does that impact the first sentence?
Yeah, my reading is they recognize that, you know, there may be some classifications and they're not, but particularly if you're coming under the surety and going armed laws, that one of the factors, one of the essential, because Rahimi talks about, it's not just it's the why and the how. And it talks about the importance of that. And the how in this case is a finding. Once a court finds that a defendant represents a credible threat to the physical safety of another. We could have a scheme where you do that. I mean, there could be a, domestic violence misdemeanor and the judge makes a finding about that after notice and an opportunity to be heard. But that's not the system that we have in any situation right now.
Thank you.
Thank you, Your Honor.
Rolani?
Thank you, Your Honor. May it please the court, Assistant District Attorney Matt Maloney for the state. I want to start near the end of counsel's argument because there were a couple of times where he did try to distinguish this case from some of the federal cases by pointing out that those cases have often dealt with felonies as opposed to misdemeanors. And that's why I do think it's important, as the Court of Appeals found in this case, to recognize the fact that the misdemeanor argument was not raised below. The defendant filed a motion challenging the statute and solely challenged it on the basis of the domestic violence provision. In his petition, he's arguing that the Court of Appeals application of the preservation rule is hyper-technical. I would argue anything but. Again, you look at that motion and it was solely focused on the domestic violence provision. There was never any argument whatsoever raised below with respect to how it applies to misdemeanor offenses. And I would argue that if you were to take the defense position and say, well, just because he filed a motion challenging the statute, then the theory was before the district court. If that's accepted, a defendant could file a motion in district court and just say, the statute was unconstitutional. He wouldn't have to say why it's unconstitutional. He wouldn't have to say what provision or what part of the statute's unconstitutional. He wouldn't even have to identify which amendment to the Constitution he is arguing was violated here. So I do think it's important, in light of some of the specific arguments raised today, focusing on the misdemeanor aspect of it, to hold that because that issue was not raised, that the Court of Appeals was correct in saying that the focus should solely be on the domestic violence portion of the statute. Now, turning to the merits of that,
I'm having a little trouble unpacking the argument. I mean, I understand the Court of Appeals limited it. I also believe that the defendant did not claim in the petition for review that that was an abuse of discretion. So let's just set the procedural part aside. I'm trying to figure out how it matters, because the defendant was convicted for domestic violence for a domestic violence misdemeanor. So isn't that the package that we have to decide, as opposed to just, in effect, the adjectives, I mean, the qualifier of the crime? I don't see how I can see how we don't segregate out to just misdemeanors.
right?
But I don't see how we unpack domestic violence misdemeanor
Yeah.
as being the conviction.
Sure, it is tricky. I guess where it comes into play is in light of some of the concessions that counsel has made, that the U.S. Supreme Court has very clearly said that there are classes of offenders who can have their rights to firearms restricted. And he pointed out a few times that has generally been in the context of felony offenders. And so to the extent that he's trying to make a distinction and say, well, you should ignore that precedent, or you should find that it somehow is not applicable here because he's a misdemeanor offender as opposed to a felony offender, I think that's where this court could make that distinction and say, well, because you didn't challenge the misdemeanor aspect of it below, you can't now come before this court and say that we should ignore the precedent, which clearly establishes that certain classes of offenders can, in fact, have their right to a firearm restricted.
What precedent are you referring to?
Well, I mean,
In what case has the Supreme Court said you can restrict firearm possession by class?
well, I think even that passage that was read multiple times.
Well, and yes, that's what I'm focused on.
Sure.
That's not a case. That's not the holding of Rahimi. It's a sentence in Rahimi saying we don't suggest that it prohibits it. But that's in the context of evaluating the historical tradition And as I read Rahimi, at least, the court and the government relied on the surety and going armed laws, which the Rahimi decision clearly says included this individualized determination. So if you have a case in which the Supreme Court said you can restrict by class, I would like to hear about it. And presumably it would have to rely on a different historical tradition than the surety and going armed laws.
I don't have a specific case site, Your Honor. I think that I think Rahimi maybe even mentioned the fact that gave some examples as far as mentally ill people, and I think maybe mentioned some other particular classes. So I don't have a specific site, and honestly, I guess I felt like even counsel was acknowledging today from the podium that is in fact the jurisprudence from our Supreme Court. So,
But what I heard is that it's in ongoing litigation in lots of different state and federal courts.
well, certainly, yeah, of course.
But leaving that aside,
Sure.
Is it true that you are relying to defend the constitutionality of the statute exclusively on the surety and going armed laws, or is there something else?
Well, I think that, and counsel's right, this case obviously was briefed before the U.S. Supreme Court's decision in Rahimi. And so in the briefing, I cited numerous cases federal cases that interpret the federal statute 922 G9. And a lot of those unanimously, every circuit court that has addressed that statute, which applies to misdemeanor domestic violence, they have all upheld that federal provision. And I think, yeah, some of those cases do talk about the surety and going armed laws. I didn't file a 609 on this case because frankly, I don't think it holds anything new. And I just discovered it was just decided a month ago. And I discovered it last week as I was preparing for argument. And I did touch base with counsel to let him know that I might mention it today. But there was a Second Circuit case just a month ago, Simmons, and the only site available for that is the Westlaw site currently, and that's 2025 Westlaw 2301317. And the language that I thought was especially pertinent was the Second Circuit said, "We join every other circuit that has addressed the issue post-Bruin in concluding that Section 922 G9 is constitutional." So I understand, and I certainly appreciate counsel's argument today that the courts that have addressed this have gotten it wrong. But I think it's hard for me to believe that every single federal court that has looked at a statute that is virtually identical to the one at play in this case, that they all have gotten it wrong in the analysis that they have performed and conducted with respect to the historical analog. And that is the key, historical analog, not a twin. And so,
and just to jump in, what I was trying to zero in on is what are your claimed historical analogs in this case?
well, again, yes, I do this, the surety laws, the going armed. I think
Is there anything else?
I don't know that there needs to be.
Well, there may not need to be. I'm just
Right,
trying
yes.
to comprehend what
Yeah.
the universe of your analogs are.
No, I would I would rely on as it was briefed, the cases that do, I think a lot of those cases, maybe all of them do cite to those.
I'm not talking about the cases. I want to know what you are relying on, what the state of Kansas is relying on as a historical analog. And you
Surety
can
law.
say anything you want. I mean,
Surety laws, going armed laws, and I would certainly adopt, I'm never going to pretend I'm the smartest person in the room. And so I'm more than willing to simply say also that I think that every piece of the analysis that the Court of Appeals panel engaged in this case is accurate. I think they accurately explained.
and I understand that. I'm sorry to just press in on this, but would you agree that it's the state's burden to present a historical analog?
Yes.
And so all I've heard from you today, and it may be sufficient for you to prevail, I just want to nail down what we're talking about, is surety and going armed laws.
Yes, correct.
Okay, thank you.
I would note that in addition to all the federal cases.
Can I follow up on that last question? I mean, you mentioned the Second Circuit case and Simmons also refers to a tradition of status-based categorical restrictions on firearm possessions before, during, and after the period of founding to disarm categories of persons presumed to be dangerous. What are they referring to there, and is that part of the historical analog beyond the surety laws and no going armed that the state's relying on?
Clearly, it would say, if you could read that provision again, Your Honor, if you don't mind.
Yeah, our nation's tradition of status-based categorical restrictions on firearms possession is indicative of an understanding before, during, and after the period of the founding, continuing to the present day, of a legislative power consistent with the Second Amendment to disarm categories of persons presumed to be dangerous.
So I think that obviously they don't spell it out there, so it's not entirely clear whether they're talking about surety and going armed laws or whether there's some other category of people. Maybe they're even more broadly speaking about some of the other categories of offenders. So I guess it's not clear from that particular provision. And certainly to the extent that I am failing to pick up on some of the other historical analogs, then obviously my words from the podium are not the only thing that matter, to the extent that there are other historical bases for upholding the constitutionality of this statute. And so, yes, while it is the state's burden, it's also well established that on appellate review, statutes are presumed to be constitutional. And again, to the extent that counsel's making any arguments that try to distinguish cases by the fact that this is a misdemeanor and not a felony, I would urge this court to not credit those arguments, because that was not raised below. In addition to the cases that specifically address the 922 G9 provision, which is the direct equivalent in federal law, obviously Rahimi was under 922 G8, and the court found that that was similar enough. And I would note that a lot has been made by the defense in this case about, well, in that particular provision, you're talking about one where there's been this finding, a specific finding of a future threat. But when you actually think about it, and I think the Court of Appeals got this absolutely right, the statute at play in our case requires that somebody has actually been convicted. It's not just a finding in civil court that somebody may theoretically pose a risk of future violence. You actually have a conviction of somebody who has a DV offense within the past 5 years. And DV is domestic violence in the statute is defined as the use or attempted use of physical force or the threatened use of a deadly weapon. So we're talking about somebody who has already had that finding or that conviction made in a criminal case beyond a reasonable doubt. And I would note that our statute is less restrictive than the federal statute, the 922 G9 provision, because the Kansas statute is limited to 5 years. And so we have a host of federal circuit courts that have held that a federal provision that is more restrictive than the Kansas provision at issue is constitutional. And I don't think that any of to my recollection, and I can't say that I remember every single, because there are many of those opinions, but if you read those in their totality, it really doesn't seem like many of those federal courts have struggled to find that statute is constitutional. There are also, I didn't cite them because they're not Kansas cases, and they're other state cases applying other states' laws, but there are also other state courts that have addressed state statutes that are very similar to the one at issue in this case. And they too have found that those state statutes are constitutional. So there has been a lot of review, appellate review, from both state courts, federal courts, all the way up to the circuit court level, of statutes that are identical or in some cases more restrictive than the Kansas statute at issue in this case. And they have all held that those statutes are constitutional. And so while I understand counsel's arguments, and I'm not suggesting that there's no possibility that appellate courts ever get anything wrong. But when you look at the sheer volume of case law addressing similar statutes to this, it is unanimously in favor of a finding of constitutionality in this particular case. We would argue that all of those cases, including the Court of Appeals opinion in this case, are well reasoned. To the extent that they might present slightly different rationale in all of those cases, they all come to the same conclusion. And we assert that this court should reach the same conclusion in this case and find that the statute is constitutional. Thank the court for their time. And again, we would respectfully ask that both the district court and the Court of Appeals be affirmed in this case.
Thank you.
Thank you, Your Honor. Justice Spiles, I just wanted to respond a little bit and acknowledge what I think is the failure and deficiency in my petition. I didn't really recognize, and to answer counsel, like, what does a defendant have to do in a Second Amendment case, down below, in order to preserve this issue and to fully get this issue in front of the district court and this court? And I think after Bruin, you have to establish that you are in the class of people protected and that the regulation impairs your ability to bear arms. And once you've done that, you've established your Second Amendment claim, and the burden shifts to the state to prove the legality of that. And I didn't assert that and I should have. But it also answers this question. If we don't have to address this, it's all about what does the state say is the justification, and then we certainly can respond to everything that the state says, whether it's at the district court or on appeal. And that's all we've done. To the extent that the state is relying in any regard, in any respect on sort of the historic tradition of being able to dispossess felons, we should be able to respond to that and say this isn't a felony case. And that's what we did.
Is that how you would, Justice Wall read some language from a recent, is it the Second Circuit case?
Yeah.
That references a historical analog and tradition of disarming categories of persons.
That there might be some categories of persons, but misdemeanor, domestic violence, battery defendants aren't, there's no category of that's historical. That's certainly true and did what we did raise below.
So that would be your response to that language from the Second Circuit?
Yeah. And the United States Supreme Court recognizes that, there could be situations where people are individually found to be dangerous. We could have that scheme here, but that's not what was done in this.
Found to be dangerous as a class, not individually.
No, that individually they have to, it's outside the scope of this case of whether, for example, any felon as a class can be dispossessed. I don't know the answer to that. There's certainly some language to that regard. And in that case, I suppose that would be like Simmons, where they would say there are some classes that can do that. But to the extent that the government is relying on surety and going armed laws to support this dispossession of the misdemeanor in this case, I think Rahimi's controlling.
Am I understanding you're conceding that there are historical analogs of class-based disarmament?
I'm not conceding that.
Oh.
I'm conceding that there is language to that effect in some of the cases, talking about, for example, felons. I'm not conceding that for future cases. I don't know. I might be arguing about felons someday.
Okay. All you're saying is that even if there are class-based disarmament historical analogs, they don't reach to misdemeanor batteries.
Yes, Your Honor.
Okay.
Well, let me follow up because I think you got to it in your very introduction in addressing what the state had cited as the classes that were perceived to be a threat, which were, religious minorities. I can't remember all the classes that you identified in your introduction.
Blacks, Native Americans.
So what do we do with that?
I think that you recognize that this generalized proposition that legislatures can just decide certain people are dangerous as a class is not true under the Second Amendment, and that neither Bruin or Rahimi stand for that proposition, particularly Rahimi.
Wouldn't that be second guessing legislative findings? And
I think Rahimi says if you're proceeding under the surety and going armed, legislative findings aren't sufficient. That's exactly what it says.
Well, I want to seize on that, especially looking at the Second Circuit decision. They make the point that Rahimi is not on all fours with the case they have in front of them, which is a domestic violence misdemeanor. Because the federal provision they were looking at required the forward-looking thing. So all they're saying is it's not on all fours. So I'm not sure Rahimi is going to control when we get into our analysis, because it's answering a different provision in the federal statute. I think it was subsection 8, right? Rahimi was subsection 8, right?
Right.
And we're talking about these cases that are looking at subsection 9.
Yeah.
So
And-
it's not so it's not necessarily controlling is all I'm getting at. We've still got to scratch our heads a little bit.
Yeah, I think it is controlling to the extent that the government, in this case, for a different subsection, is arguing that the historical tradition of regulation is the same thing as was put forward in Rahimi. I do think Rahimi is controlling on that. Thank you, Your Honor.
Okay, thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement.